everyone, and welcome to my seminar entitled Everyone's a Loser, the Canadian Sexual Assault Trial. And I'm here to talk to you today about what I call the justice system's dirty secret. It won't be hard for you to find lots of different people complaining about the system insofar as it relates to sexual assault. There's a lot to be critical about, but what you are rarely likely to see is one of the true forces and the true factors that's at play in creating a system that we cannot be proud of. And I'm here to talk to you about it today, mainly because I think it is a really problematic area of law, and I'm kind of worried it's causing our justice system to crumble. The first thing you might be wondering is why you should listen to me. Of course, lots of people don't agree with me about a lot of different things, but I have been a law professor studying the criminal justice system for 25 years. Since 2017, I've also been a litigator. I have appeared in sexual assault proceedings at every level of court, and I've appeared in the Supreme Court of Canada arguing about how sexual assault matters should be treated. I don't have all the answers, but I'm telling you, I have plenty of questions, and that's what this presentation is really about. It's about bringing to light concerns that need to be discussed if we are ever going to solve any of the problems we have with the criminal justice system. And I'm telling you, now is the time. I am recording this the day before the verdict comes down on the London hockey trial, and I'm telling you, my concern is that that is going to be another situation in which outrage on one side or another is going to prompt us into some really bad decisions about how we can fix the sexual assault trial. I'm here to issue a warning. Every one of our fixes has created more problems, and right now we're still dealing with the last round of fixes, and we are no closer to creating a system that is likely to produce results for anybody. My theory is that everyone is a loser when dealing with sexual assault matters, and this presentation is going to explain why that is. So I'm going to start with a basic proposition. You may or may not agree with that proposition, but that's where I'm going to start. I believe we're in the midst of the most significant criminal justice system crisis in modern times. I have given this presentation many times to judges, to groups of defense lawyers, to mixed groups of defense lawyers and judges, and the public at large. But I believe we are having a crisis already, and we are not acknowledging it. I say that because we are constantly trying to fix things in the justice system without looking at the justice system as a whole. I don't have the answers for every part of the justice system, but my proposition is this, that the way we are currently dealing with sexual assault trials is unsustainable, and as I said, is causing everyone to be a loser. Why? What is at the core of the problem? Well, I'm going to start with the fact that it is even difficult to talk about this problem, and I can tell you that for my part, I have been concerned since first becoming the one to speak out about the system that I'm going to face a lot of backlash. It is a very difficult problem. It's a very difficult societal problem on which people have a multitude of opinions. Today, we are supposed to believe survivors at all costs, and I'm going to suggest that there's good reason for that to a certain extent, but what we are dealing with here goes beyond that. The biggest problem, I think we don't talk about it, is because the solutions to the problems that I'm going to suggest to you, while I think they exist, are very, very complex and going to be very hard to sell to people. My belief is that we're all going to have to compromise if this system is going to become workable, or else we'll continue to all be losers through the criminal justice system. I think the crisis is already here. I'm just trying to speak about it and show that it actually exists in a way that is tangible, but it's here whether we want to discuss it or not. So what do I mean by the crisis is here? Okay, well, let me explain. I'm going to give you an example of a recent sexual assault appeal that I was involved in. I was surprised by the fact that the accused was convicted and the conviction was overturned on appeal, but that's not what I was concerned about for the purposes of this talk. What concerned me is that this was a two-witness trial, the complainant and the accused, and it took a total of 18 months to complete from the first trial day to the verdict. Now, I don't even know how that is possible, but it was possible, partly because they had 14 different trial dates, mostly to deal with what are called vetting applications. Applications that are designed to determine whether evidence should be admitted. And all of these are now applications that require 3 lawyers to get together because the complainant has counsel as well, and figure out when they can get together to discuss these problems. There were a total of 6 applications, many of them revisiting applications that had already been decided. The dates become very difficult to do because when you get 3 lawyers together, it's actually hard to measure their trial calendars with the trial judge once things have gone beyond the ordinary date. This is no longer a complete aberration. The appeal, unfortunately, was allowed in this case on the basis of how the judge resolved the Section 276 application. And what does that mean? This is an extreme example. I don't want to tell you this goes on every day, but I will tell you this. It is less uncommon than you think. Extended trials for sexual assault are a dirty little secret that everyone in the system knows about. Lengthy pretrials and pretrial conferences to prepare for the pretrials, lengthy written applications, all of these things, well-intentioned, correct or not, that's not my position. I am here to tell you they're extremely inefficient. Every time I have presented this to judges at the lowest end of the spectrum, provincial court judges, superior court judges, they nod because they know that this has become a war of attrition in the sense of consistently putting applications together to get matters resolved. I advise everyone here, if you don't believe me, go read a decision of a trial judge who had simply had enough in a case called Larson. That same judge wrote another case called Larder, and here was his take. Once relatively straightforward, sexual assault trials have evolved into subsequently intricate proceedings stretching across courtroom calendars in a matter once reserved for murder. I'm going to say right now that murder prosecutions, which remain very complicated, are actually less complex now than sexual assault because we have so many different procedural mechanisms that are only applicable to sexual assault. And now what previously might have unfolded over days now demands judicial investment because all of these things are in-court procedures where we've really expanded the nature of what has to be vetted before trial. Justice Rybchuk goes on to say, what I think is obvious, but not everyone is talking about, places considerable strain. Trial delay is one of our biggest problems in the system, but sexual assault law is contributing massively to that delay. So I'm here to tell you that this strain is real, that this judge knows what he's talking about, and that this is actually happening. I'm not here to take a position on these vetting applications are good or bad in a larger sense. I am here to say we have to acknowledge that the system is straining under the weight of these constant vetting and conferences, all designed to prepare us for trial. I like to say to some people what I've said is, we've adopted the very worst of the civil system, which is known for its lengthy pre-trial process, and for sexual assault, we have accidentally or intentionally adopted that process in full. My thesis is this. This is not good for the system. It's that simple. I'm not here to tell you about whether it's good for any particular party, but I am here to tell you it's very bad for the system. I don't think this is accidental. We have created a number of rules that are essentially or ostensibly designed to delay the system. That's what they do. As soon as we shift everything from the trial, which is straightforward, to the pretrial, there are incredible consequences to doing that. And I believe the strain is apparent everywhere we go. I hear about it every day as counsel continue to ask me, do we need applications for this? What sorts of applications do we need? And judges continue to set matters over, request additional pretrial conferences to figure out the confines and the nature of the evidence that can be called. That is what we've done ostensibly on purpose. My assumption for the presentation is simply this. If you don't agree with this assumption, then you can't agree with the rest of my presentation. But the more complex we make our rules, and the more ambiguous we make those rules, and the more that we essentially try to find ways for lawyers to disagree with each other about basic propositions, the more we are going to delay something. And nowhere is there more disagreement in the law than in the area of sexual assault. Frankly, it's not even close. Defense lawyers, crown attorneys, and judges do not see eye to eye on most of these provisions, and the constant struggle to have all these matters litigated is creating an incredible amount of delay. It's not just me. Thankfully, very recently, Chief Justice Wagner said in a case called Kinnamore, the first paragraph was the first acknowledgement from the court that complexity is posing a challenge. Unfortunately, I don't think this case reduces that complexity. I think it increases it, but I certainly like the sentiment. It is a real problem. If we don't do this, we are causing unnecessary confusion and disruption. And as I hope to show you through the rest of this presentation, everything we have here is ripe for confusion and disruption. My primary focus for this presentation is not taken from my role as a defense lawyer, not per se, except what I've learned in that experience. I'm going to assume that the changes that I'm about to discuss are good in the larger sense. I'm going to assume that they correctly reduce the prejudice to complainants and the system, and they sort out who should be convicted by getting to fairer outcomes. I don't actually believe that, but you won't hear me in this presentation talking about the defense, because truthfully, I think most of these vetting provisions and the things that I'm about to discuss are unconstitutional, even they have been largely upheld by the courts. I am deeply concerned about the shredding of constitutional and evidentiary norms, but I am focusing in this presentation strictly on the issue of efficiency. So the first thing we need to understand, if we're going to understand what a crisis we're in, is how did we get here in the first place? The problem is there has been a need for change in the area of sexual assault for a long time because how we've done things historically was generally just not good enough. The truth of the matter is there has and continues to be genuine concern about the legal treatment of victims. So I am not necessarily attacking the cause of the problem because that is a real disease. There is a real concern about the legal treatment of victims, and I do believe there are some solutions to that could be adopted in a way that is sensible. But even bigger problem is the enhanced concern about the actions of the Crown, the defense, and judges. That has been a 2000s problem, largely, in which we have started to look more closely on how everybody does things. And I could throw out 3 names for you. One is Robin Camp. The Robin Camp issue was a massive problem, and the way he acted in a particular case was indefensible. I'm not here to defend it. I've criticized it from the moment I first read it. Robin Camp's approach to justice and approach to complainants was completely wrong. It was based on completely mythical thinking. It was based on ideas that have no place in a courtroom. But at times, the cure for this problem is in some ways perhaps worse than the disease. And I like to say about Robin Camp that he did more than any provincial court judge has ever done to influence the course of justice, because what's come about as a result is really something to see. The Jian Ghomeshi case was a massive concern. It raised public awareness in a way like never before. There's never been a Canadian case that attracted that much scrutiny on a day-to-day basis. And from the point of view of complainants and survivors, this was a nightmare, even though Mr. Ghomeshi was acquitted for reasons that most legal experts, including myself, say were completely legitimate. That is the way the burden of proof operates. But the Ghomeshi case was seen as a social problem that needed a political solution. And finally, we are here again with the London hockey team. There has been incredible media scrutiny. Sorry, it's not the London hockey team, it's the London hockey case. But we have seen incredible scrutiny about the way the prosecutors have run things, about the way the defendants have run things, about whether or not the complainant is telling the truth or whether she is not telling the truth, and how we treat survivors in the courtroom. And all of these things have enhanced the concern. So sexual assault, unlike fraud or even murder, is under a constant microscope, and it doesn't stop there. There has been incredible case growth. People say we don't prosecute enough sexual assault prosecutions. I'm here to tell you that we prosecute a lot of sexual assault cases, certainly a lot more than we used to, ever since a couple of events have taken place. One is, we actually did a study, the Globe and Mail did, and it found out that we have a serious problem. Police and Crown were undervaluing the importance of these cases, and I take no issue with that either. I'm just here to suggest that if you increase the input into a system that is dependent on input and output, you're going to lead to congestions in the courtroom. So there is a great deal of pressure on police and Crown to charge. And in my experience, cases are prosecuted regularly, even where the case for conviction is unclear. There seems to be less vetting of these cases and more willingness to take them to trial. We've destroyed plea incentives. No one has any incentive to plead, and I'll explain why that is in more depth. But I can tell you that all of these mechanisms, which are designed to help survivors, have ramped up the stakes. And again, this is not a comment on whether we should or shouldn't do this. If you want to see the trials that are fought the most contested way, where nobody pleads guilty, it's murder, where you cannot make a manslaughter plea, and sex assault. And the reason is there's just not that much to gain. We've messed with the basics of incentives that lead many people to plead guilty. What do I mean by that? Number one, we've added more cases to the problem. I've already said that. The criticism of prosecutors, judges, and defense lawyers has really enhanced scrutiny of the system and has caused everybody to want to get it right. Well, wanting to get it right is an admirable goal, but wanting to get it right means that we are going to take longer to do things. Nobody wants to be Robin Camp, not the least of which are the judges. And I can tell you, I've spoken to many of them off the record, they are scared. They live in these communities too, and being called out for being a Robin Camp sexist, I don't like it either. As a defense lawyer, I've been called sexist and advancing sexist stereotypes more time than I can count. These things have a real impact on people, and that, again, causes delay. Everyone wants to get it right, and if they're doing that, it's taking more time. The SOIRA regime, which is the Sex Offender Information Registry Act, has made it very difficult for anyone to plead guilty. And again, you might wonder why we want people to plead guilty, but guilty pleas are the lifeblood of a healthy system. We need people to plead guilty, and if they're getting what are mandatory registration orders for, on some occasions, life, but often 20 years, and the stigma that a sexual assault conviction is literally worse than almost anything short of murder, it's very difficult to plead. And the reason for that is simple economic theory. If you're getting a jail sentence, which is almost inevitable for almost any type of sexual assault. There has been some movement recently so that there are ways to get a conditional sentence order, a lengthy one, for all sexual assaults are serious, but there is a divide in the law between a major sexual offense, which involves intercourse or penetration of some sort. So for certain types of offenses, it is possible to plead guilty, and people will plead guilty if they can avoid jail, because they're worried as well about violence in jail against sexual offenders, which is a reality for many people. The problem is it's very difficult to advise an accused person to plead guilty, even if the facts support it. And the reason for that is, like, you are looking at 3 years for intercourse minimum of any type of sexual assault. It doesn't really matter what the nature of the assault is. If it involves intercourse, you are looking at 3 years as a starting point. And the bottom line is, if you plead, you might get that down to 2. But it's very difficult to convince somebody to plead of these things when the incentive to do so is so marginal. And again, like, the reason so many people plead guilty to manslaughter when that's on the table is because manslaughter doesn't have life imprisonment and a mandatory period of parole and eligibility. So the accused is able to move on from that event and still have some sort of life. Here, the smaller the distance between what you're going to get and what you could get is just... It's very hard to sell to an accused person who sees their life flashing before their eyes. And that's not to say that I'm encouraging people to plead not guilty, nor is it to say that people who do things shouldn't express remorse for what they've done. I'm just here to tell you the realities of the incentives that are pushing against a plea. At the same time that we're pushing more into the system, we're constantly changing the rules, which I think generally as a law professor is a terrible idea. I understand that we're trying to correct injustices, but if we're constantly changing the rules, we have problems. And the problem is that sexual assault has been one of the most prominent areas of legal change that there is. And again, I'm not expressing any comment on the merits. I like a lot of these cases. I think they reach the right result. But most of these cases have the impact of making the law a bit tougher to navigate and a little bit more complex. And every time we do that, we are making problems for ourselves at the trial court level. I'm telling you that the law is so complex that, like, the statute has changed as much as any statute that there is. Like, the criminal code never gets reformed, but the rules on sexual assault do. Those are reformed regularly. And after each reform, we have the issue of trying to deal with it. Every one of those changes, by the way, has been followed by constitutional challenges, which take several years to get up to the Supreme Court. Many of them have interpretive challenges where we're trying to figure out how these rules should be enforced. But the common theme about all of them, these are all rules that only apply to sexual assault, making them a particular battleground since we have so many cases coming in. And every one of them battles these out individually. I'm telling you, when all those things were going on, it took 3-4 years to get this to the Supreme Court. There were challenges in every jurisdiction. You had different provinces with different rules. Eventually, it gets sorted out, though, as you will see, the sorting out usually causes more difficulties that tend to be litigated heavily. In JJ, which is the famous case about the records regime in Section 278.92, the Supreme Court made it clear that this is a problematic area of the law, that we need to do more for sexual assault complainants. And saying all these things that, by the way, were contrary to basic norms before the Supreme Court decided this in JJ, but in any event, they have encouraged more. And the more changes that we make that are solely for sexual assault cases, the more difficult it's going to be for any litigator on the ground. I talk about it and I call it the sexual assault vortex. I say that when you're doing a sexual assault trial, it's very easy to slip into this vortex. What I mean by that, again, is not a good, bad thing. I have feelings about each of these rules and I have my own views on whether they're good or bad. But what I know for sure is they are a massive departure from the way we decide any other case. As such, if you're a lawyer, you're either a sexual assault lawyer or you're a criminal lawyer who doesn't handle sexual assault, because to be honest, you need to understand another body of law just to do sexual assault trials, and that's how complex it's gotten. So, what are the changes that have impacted delay? In this presentation, I'm going to focus on 3. The substantive rules about the mens rea for this offense, the evidentiary concerns involved in Section 276, which is sometimes referred to as the rape shield provision or the sexual history provision of the code. And finally, I'm going to deal with the records provision in Section 278.92 and the recent decision, 2018, to allow complainants to have their own lawyer in these types of applications. I'm not going to touch on some of the others. The meaning of consent is continuing to evolve over time. I expect that the London hockey trial is going to delve into this in some way about what it means to consent in the face of significant pressure. These are all things that are constantly evolving. We think consent is simple. It's really not the case. The concern about myths and stereotypes is, if I was doing this talk in 3 years, and I hope I'm not, I hope things have changed, I would be talking about myths and stereotypes, because that is a very big concern. It takes a lot of time in trials to figure out what you are allowed to do and not allowed to do with certain types of evidence. And finally, third-party records continue to be a concern and something that affects delay in sexual assault trials. But I'm going to focus, as I said, on the top 3. So first and foremost, when we're talking about concerns, sexual assault is complex as an offense. It tends to get dumbed down a little bit when we're talking about it, in newspaper articles or whatever, and that's not to criticize them. Most people understand sexual assault as being, centered around the issue of consent. It's not that simple. There are lots of types of sexual assault that raise real questions about, is consent enough, or is lack of consent enough to ground a conviction? And there's always a lot of questions about that. But one of the biggest is the question of the mental element of sexual assault and its relationship to the physical element of consent, also for sexual assault. And it was described in this way in Uinchuk, and this is very familiar to most lawyers and law students. The absence of consent is subjective by reference to the complainant's subjective internal state of mind. I take no issue with that. That's fairly settled law, but I'm telling you that this has gotten more complicated in the ensuing years, because now we're often seeing consent, which was designed, by the way, to shift questions about meaning and misunderstanding to mens rea. And to explain what that means, in Uinchuk, the suggestion was that you could imply consent, that even though a woman didn't consent, you were entitled to imply that it was there, notwithstanding its subjective absence. And I know some of you are thinking, now that's completely unrealistic. It's not. We do that with respect to regular assault all the time, in the sense of hockey players don't walk up to each other and go, "Excuse me, can I body check you into the boards?" I don't want to be body checked. No, because you don't want to lose the puck. And I'm not equalizing them. I'm just saying that the concept of implied consent actually has legal meaning. But the Supreme Court was, in my view, quite correctly prepared to say we're not going to do that with sexual contact, because the nature of the activity is too invasive and too intrinsic to a person's bodily integrity and dignity. I take no issue with that, But the goal was to say if the accused misunderstands what's going on, right? That's a mens rea concern, whether or not we punish them on the basis of their mental element. But the more I read from the Supreme Court, the more I think that these are blending again. And if you look at the language here, I'm not sure this is the same as Uinchuk. I'm not sure that contemporaneous affirmatively communicated consent must be given. That might not seem like a big distinction to you, but in Uinchuk they said consent must be present. And here they're talking about positive affirmation and the possibility that you can be convicted simply because positive affirmation wasn't given, and that tends to again bring up this confusion between the elements. It gets a little bit worse because this is what arguments are about. I'm talking about delay, and I know that this argument is made regularly. No consent was given, but consent doesn't have to be given. It has to be present, and these are arguments that take time to resolve. And frankly, I think it should be clearer than this. But the biggest problem is really about what mental states we should punish. It's kind of amazing to me that we've been doing this for, in the modern era since 1985, and in the revamped era in the early 90s, where we put in some of these provisions about mens rea, we still haven't decided when we should punish an accused. And it's kind of amazing to me. But if you look at the language, it's actually quite confusing, because if you look at assault, sexual assault is built on assault. So a person commits assault when without the consent of another person. For assault, it's unquestionable that the mens rea elements are applied by the common law. So in other words, you can't convict somebody of applying force without consent unless they knew, moral certainty, or were reckless about whether consent is present. But sexual assault doesn't apply the common law because it has a statutory overlay. The problem is we don't know what that statutory overlay means. So here's what I mean by that. Sexual assault has sections 273.2 that say it's not a defense to sexual assault that the accused believed that the complainant consented to the activity. Now the problem is it then sets out the two mental states that I agree arise to conviction. So if the belief arose from recklessness, as I said, recklessness is a culpable state already, or willful blindness, which is equivalent to knowledge, saying that the accused shut their mind to whether consent was present. That's no problem. That first part is completely equivalent to the common law. But the problem is that there's an or. And the or says this, that the accused did not take reasonable steps in the circumstances known to ascertain that the complainant was consenting. So what does that actually mean? I thought I knew what that meant for years. I thought it meant that the accused would be found guilty if they didn't take reasonable steps. Because to me, this issue of a defense was simply describing mental states. And that was my belief as a law professor right up into the early 2000s. But all of that has shifted, and all of that has raised new questions. So what are those questions? Well, number one, is this what's called an independent pathway to conviction? What it means is this a way in which we convict anybody regardless of their state of mind, right? Regardless, if they fail to take reasonable steps. If you pose this question to any law professor, judge, or lawyer, you're going to get a different answer from everybody. Nobody really knows the answer to this, but we just keep going along and litigating this on a regular basis. The other question that comes to mind to me is, I don't know how this can be constitutionally compliant. I don't understand if this is an independent pathway, and people have been convicted on this independent pathway many times. I don't understand how it's constitutionally compliant, because if you use this as a reason to find guilt, you're essentially punishing someone on the basis of a failure to act in an objectively reasonable manner. And the Supreme Court has very recently stated that the minimum state of blameworthiness in this country for a criminal offense is criminal negligence, which is a marked departure from the ordinary standard. So this, to me, is a question that remains open and that most courts try to dodge. They try to get around it in some way by saying one thing on one occasion and one thing on another occasion. Don't believe me? I don't know, go look it up. Like, the question comes down to whether honest mistaken belief is the same thing as the mens rea. And let me set the stakes for all of you. If honest mistaken belief is not the same as mens rea, then I have no idea what role the reasonable steps provision actually plays. Because if honest mistaken belief is separate from mens rea, then if the accused is not reckless, he's not guilty. But if it isn't the same, I don't understand what the point of the provision is, because there's that big or in it. So I don't really know what we're supposed to do with that. And quite frankly, neither do the courts. Morrison is part of the confusion, because I would have liked to have seen all of this get assessed on what I believe to be the truth, which is that the defense is simply another way of describing the mens rea, because to me, that's what it is. It's the only way that logically makes sense with the provision. And quite frankly, I don't really understand how you would really describe this in any other way. There have been a million cases that have said that the defense of honest mistaken belief is the same thing as the absence of mens rea. But in Morrison, they said it's not. In this other context involving luring, they said, well, it's completely different. And as a result, again, I'm not here to discuss this. I'm just here to say, what are we doing? How can we be arguing this constantly? In British Columbia, they say, nope, mens rea, that's it. It has to be based on reasonable steps. In Ontario, they say other things. We're going in circles here. And if you look at the case law, sorry, I just jumped one. If you look at the case law, the case law is all over the place. It's not very good. You have cases that really within the same courts that don't make sense with each other. And it is a real problematic thing, because I'm not here to resolve this. I've already made my position clear on what I think the section is. But how do we not know? How do we seriously not know and have this argued in courts every day, every single day? I mean, frankly, there are two underlying concerns here. One is, do we want to punish those who are honestly unaware that the complainant is not consenting? I think the answer to that is yes. I do, but I also think that that is a question that needs to be determined under the Constitution. And then the question is, what does that actually mean? That's just me. I'm just telling you that the answers are not clear and everybody's arguing about it on a regular basis. That leads us to our bigger problem: evidentiary and procedural confusion caused by sections 276 and sections 278.92, which I call the beast that swallowed the world. And I say that because they are literally a beast that is swallowing the criminal justice system. It is the hungriest beast I've ever seen. It is consistently expanding to take in more and more information, and most people seem to be on the sidelines going, yay, let's do more of these. Those of us in the system are not saying that. I mean, I guess there are some people who like all these applications, but I'm not one of them. I think these applications are enormously complex, and I'm not convinced they're actually achieving anything useful at the end of the day. Why do I say that? Well, let's start with what they are. Again, I take no issue with Section 276. I think it had admirable intentions from the outset to do something useful. I honestly believe that sexual history is almost always irrelevant, whether it's the sexual history between the parties or the sexual history between the complainant and another person. That's not always true. I can invent lots of situations in which it's highly or extremely relevant, but nonetheless, I have no problem with the mechanism. The mechanism actually makes logical sense. The problem is that the pretrial applications have become more complex. In other words, Section 276 is not your father or mother, section 276, because it's changed dramatically. I had a few issues with the old one because it was complex to apply, but the new one, the 2018 version of section 276, is an absolute nightmare. Why? 5 changes have happened. This was supposed to cover sexual activity. Instead, it covers just about everything under the sun. First of all, the scope of the offenses, like this doesn't come up in every trial, but we don't even agree on what it applies to, because we've created common law versions of the same rule, and maybe it applies to things that are closely connected to sexual assault. It's just kind of difficult to ascertain. I think the inclusion of sexual communications in 2018 was one of the worst ideas we've ever had. The problem is, I don't think anybody anticipated the social media text communication. And the problem is that if you treat every sexual communication as sexual activity and inadmissible, you're no longer within the basic structure of 276. Like, I get it. Just don't get me wrong. I don't really think it's that edifying to know that the accused and the complainant had sex on a prior occasion when you're determining if it's a sexual assault on the second occasion. But I can't jump to that same conclusion when it comes to sexual communications, because many of these communications will relate directly to issues that are at trial. So, for example, to take the most obvious, the basic statement of the text message of the complainant saying, I want to do A, B, C, and D when I come over, and then comes over and alleges a sexual assault for A, B, C, and D. Like, if you're going to tell me that evidence should be irrelevant and vetted or excluded, I just don't agree with you. I'm not saying it's determinative, because it's not, but I think communications of that type are indicative of things that are different than sexual activity. Like, the problem is communications are infinite in nature, and as it turns out, people like to communicate about sex. Every meeting is set up on text, and we've expanded. Section 276 is a growth industry. What else? Now we include Crown evidence. I mean, honestly, most of my colleagues love this because, they feel that the pain should be equally shared. But I think this is a nightmare. The idea that the Crown should have to go through applications when the statute specifically excludes them, I don't think it's logical. I think it's nonsensical. I think the court is dead wrong in those cases. I just don't think it helps to say that now the Crown and defense can both have applications. I don't know what to tell you. I don't think this is good, and it's leading to more delay. You can't agree. Do you know that defense and Crown can agree on almost anything? Literally. They can agree on evidence, they can agree on procedure, they can agree on mode of trial. They can't agree on 276, which means it has to go before a judge. Again, if you want to go before a judge regularly and have stage 1 and stage 2 applications, great. But excluding consent is a terrible idea, in my opinion. And now we've brought in another lawyer. I personally think that there's no problem in the world that's ever been looked at and said we can solve it with more lawyers in the equation. And let me just state, I have no issue with complainant getting counsel. I think that's wonderful. I think all witnesses should have lawyers, and certainly complainants. But to have those lawyers argue means you're expanding the procedure and you're expanding the time and length of the proceeding, and all these things add up. Finally, everybody has to fight about it with lengthy paperwork because the judge has to record written reasons. It's the most complex section to apply in the code. The arguments around 276 are legendary and they are legion. They go on all the time. It's not an easy section to apply. And it's the problem is with the complainant getting involved, defense lawyers are naturally inclined to not want to give over communications and things like that without notice. So there is a lot of fighting going on about it. And what constitutes probative uses of sexual activity is constantly under attack. So these sections are just continuing to provide difficulty in court. And of course, the Supreme Court has said, well, we can reopen them. That's what happened in the appeal I started this with. We can reopen and relitigate these things as circumstances change. And you think, well, that's a rare case. It's every case. Often when you're litigating a 276, if you've done these before, you're often doing them on the basis of very scanty information. It's even worse for text messages. I don't really know what the complainant is going to say until she says it. So it is not uncommon for the complainant to massage a version of facts, or I don't want to say that in a way that's negative, to give an expanded version of thoughts at trial. Like it's expanded. But that means you have to redo the Section 276 application. It happens more often than you'd think. And finally, we come to Section 278.92, private records in the hands of the defense. I am not a fan. I do not think this was a good piece of legislation. I think this is a piece of legislation that has dramatically complexified the sexual assault trial. I think this is probably the biggest offender because, as I said to you, most people like to communicate by text and message. And while sexual communications are the problem of Section 276, most of these are not sexual communications. They're providing some sort of information that the accused wants to advance at trial. Now it has to be vetted. The Supreme Court in JJ took as broad an interpretation as they could. And I think that was a very bad thing for the system of justice. I don't think anyone can look at this and see the impact of what the Supreme Court did in JJ and say that this has enhanced the system that we are working under. What it's done is it's created a lot more vetting, a lot more than anybody anticipated we would ever do. So that, as Justice Rybchuk pointed out, we are deluged daily in the courts with 27892 applications so that we can look at text messages in great detail. The defense gets to decide if the section applies, which is why I get so many calls asking me if we have to turn this over or not, because as I said, the defense doesn't want to turn things over if they don't have to, and this is the only section that makes them do that. So everybody's saying, well, do these qualify or not? And you're in a tough position if you're the defense lawyer, because if you don't do it, you might not get these things admitted. A lot of difficult questions that are all going to be vetted out in court, often with a motion for directions where the defense applies to say, are these even a record in the first place? I'm not sure. I don't think so. Not a great system. The balancing of admission for this section is incredibly difficult to do because it's contrary to every other rule of evidence and every other system that we have. And what do I mean by that? I don't have any issue with Section 276 because Section 276 measures two related concepts. The evidence will be admissible if the prejudicial effect, which is the likelihood that the jury will be led astray by the evidence, outweighs the probative value, which is the likelihood, substantially outweighs the probative value, which is the likelihood that we will get to a better outcome. I don't take any issue with that. That basic formula is used across the law of evidence. But Section 278.92 doesn't do that. Section 278.92 measures the probative value, the utility of the evidence, against the privacy interests and dignity of the complainant. And I'm just here to tell you that there's a reason why we don't have those types of balances in the code. Because number one, anywhere else, we don't want to be balancing that. The trial is supposed to be about the trial. And if you're measuring interests outside of the trial as a reason not to get at the truth, that is really problematic. And judges don't like it. It strikes against what they're normally doing. And it is weird to me that we would introduce that type of balance when we're talking about admissibility. And for those of you thinking, well, but we do that with records production, which is the other part of Section 278.1, I take no issue with it during records production because when you're trying to produce a record, balancing privacy against probative value is a good idea because the question is not about admissibility. It's not the trial that's using it. You're trying to seek it. And I take no issue with saying you shouldn't be able to have it where the privacy interest substantially outweighs the probative value. But at the trial stage, That is very dangerous. And it's also not very easy to measure abstract context. Like, which is more important? Getting an innocent person to be found not guilty, or like privacy interests? I don't get it. I don't think that's an easy thing to do. And this idea that was propounded in JJ, like I've cited this paragraph, like as an evidence professor, I have no idea what this is talking about. It's an interesting idea, but we can't look at fairness to witnesses when assessing the costs of admitting evidence. Like, that's not a good idea, because like beyond the sexual assault realm, like what if we were assessing the costs and like the court is requiring me to divulge very private secrets I have, and if I divulge them, my wife might leave me. Like, is that something the court should consider? And if not, why not? But I don't think that's a good idea, because that's not the court is not a social agency, and it's not designed to balance these things. And it doesn't do them very well. So I'm very concerned about that idea to begin with. But again, for the procedure, I'm just here to talk about complexity, because the court said that pretrial should be the practice, which leads to revised applications later at trial. They have to measure this complex idea of physical, psychological, intimate information. They've helpfully stated that when it's unclear, have an application. Like any rule that starts with when it's unclear, have more pretrial applications, you're just exacerbating delay. I understand that people don't like some of the results in these cases, and we've unleashed Section 278.92 and 276 to get all this evidence vetted, because most times it goes in anyway. But like, if you're going to do that, like, this beast is starving. It's always hungry. You're not going to just get defense lawyers. You're going to get prosecutors. You're going to get judges. You're going to get justice. You're going to get everybody. It is going to swallow us all. And I'm not exaggerating when I tell you that too many of our courts are engaged in pretrial vetting applications for my liking. This is a real concern for the efficiency of the justice system. Let me tell you, my belief is when you continue to go after this stuff, you're going to have problems. The scope is now enormous, and everybody's constantly contesting the scope. You end up with these scope problems. I already told you that I think there are barriers with privacy over the normal evidentiary process. The distinctions are so hard to navigate at this point. When something is going to be admitted or excluded is very difficult to figure out. I don't like this either, that everybody's got to get adversarial about it. It's mandatory adversarialism. Even where it's crystal clear, the Crown cannot consent. We have to bring three parties in and negotiate whether it's admissible. As I said, things change. It is not uncommon. If you've been a trial lawyer at all, you will know that things change. The procedural barriers make it constantly challenging to schedule things. We have to arrange complainant's counsel. We then have to ensure that complainant's counsel is available even when things arise at a very late stage. In jury trials, I don't know how anyone ever does this, because if you have an unexpected matter come up in a jury trial, you have to stop the trial and you have to go get complainant's counsel, because none of these things are fast. No matter how fast you try to deal with them, the code requires certain things to be done, and it really doesn't take into account how jury trials actually take place. That's my statement, and I'm sticking to it. Delay's an evil. This is the worst offender. The beast is terrible for delay. I don't think the results it reaches are great either, but I've said already I'm not going to focus on that in this talk. So, what has all this change done? We've tried to make better and fairer outcomes, but we changed the rules consistently, and we set up a distinct system of procedures that only applies to sexual assault. So what are the results of all that? Like, the complexity is off the charts. Take it from somebody who deals with these applications regularly. Like, I'm a law professor and I read all the cases. I have the luxury and time to do that. And when people call me about 276 or 278.92, I've really got to look it up. Like, I've got to figure it out, if it's covered, if it's excusable. And that is just a lot to put on people who are trying to run trials on a day-to-day basis. There's just almost no predictability. The rules change so frequently on these matters that, nobody knows. I mean, Kinnemore recently decided that the Crown was bound by all these rules and now has to have these new procedures where they try to work things out with the defense. It's complex. Mostly it encourages disputes. Like, the more ambiguity and complexity there is, the more room there is for people to contest what's actually happening. And that is the reality of it. If you combine that with reduced pleas, you can see how the system gets gummed up in a real hurry. What does it do? Well, I think the impact goes beyond sexual assault trials. If you're going to start delaying, everybody's saying now we should revise the Jordan rules and we should stop throwing out cases for unreasonable delay. And I'm just here to say, I don't think Jordan is the problem. I think we need to have a strong look in the mirror and say, what are we doing to expand the time it takes to go to trial? And part of the answer is the way we deal with sexual assault cases. I never hear anybody say that we have a system of input and output. And at a certain point, if we continue to jam more procedures in the front end, we're not going to get trials through the output stage. And, questions about productivity, even if it's only a 5-day trial, why is it taking so long to resolve these matters? And the answer is vetting. Mostly, that is the main culprit. I think everybody's losing. Everybody. And I say that, for everybody, including defendants. These cases take forever to litigate. And everybody, the stigma of a sexual assault allegation is very high. The cost has gone up dramatically. I'm a defense lawyer, and it takes a lot to retain me and have me to go through multiple applications. I remember when JJ was decided, I said, well, the first result is that everybody's going to quote more. Because at the end of the day, if you've got to do multiple stage pretrial applications, and I heard from a lawyer recently, now we have to charge for conferences because there's pretrial conferences about the pretrial applications to try and scale them. It is a messy business for defendants, leaving aside the wrongful results we sometimes reach. All of this was designed for complainants. I don't think it's been very successful in doing things for complainants because the delay is really painful. There's so much time spent on procedural wrangling, and now the complainant is a part of it. I'm not here to paint a picture of a unique complainant, but what I know from actual experience dealing with complainants in these matters, directly and indirectly, is that some complainants want to be involved and some really don't. And sometimes they don't know if they want to or not until they're in these multi-stage applications. I don't think these decisions are really helpful to vet at length and in detail. And yes, it helps to have counsel, but it's not always a decision that assists. You have more appeals and fewer guilty pleas. That is the result of the system that we've created, and I don't think any of that's good for complainants either. Prosecutors, to me, it's not good for them. The pressure's relentless. They get held to blame. When they have longer trials and these trials start to break up, the Crown gets held to blame for all of these decisions. And it's they're the ones who usually have all the witnesses scheduled, and just a sudden breakdown in the trial to deal with emergency applications really isn't good. I don't think it's helped with the adversarial discussion. I'm going to tell you that I never get into debates or arguments with a Crown on a drug trial, a murder trial, or a fraud trial. But I don't like being called sexist or advancing sexist myths when I think I'm just putting in evidence that's useful to my client. And I really sense that the adversarial discussion has really ratcheted up in relation to these types of trials because we disagree on so many core issues. And yeah, as I said, when you're scheduling a trial, you can get caught off guard. It's tough on judges. I've met with judges. I've talked with them about these cases. No one wants to be the next Robin Camp. They live here. They live in their communities. And like being plastered on the front page of the Globe and Mail as Robin Camp is not something they want. They want to get it right. And that takes longer. And the Supreme Court stomps on everybody, which no one likes if you're a judge. And they have done that repeatedly, making judges a bit gun shy in this area. Especially when they're getting criticized for things they do. I point to this one in particular because I don't think the judge did anything wrong in this case. I think this is overblown rhetoric saying that the judge applied a myth when it seemed to me they were just applying reasonable doubt. But certainly they are aware of the scrutiny that they're under. I mean, the only possible winner are defense lawyers, but it's bad for them too. This has become such a specialized area and it's so difficult to work. It's not fun work most of the time. It's like you're into a lot of really difficult cases and you always think you're getting it wrong for your client. And for legal aid clients, man, you got to have a strong stomach if you're going to run multiple, endless applications to try and do the best you can for your client. And when you're a legal aid, you're trying to get some certainty as to how long this is going to take. Judges are regularly asking for written submissions on this area. And it's because everything's gotten more complicated, that is a concern for somebody trying to run a practice. Biggest loser? All of us. This is bad. We're losing too many cases to delay. I am not a fan of Jordan results, but I am generally a fan of Jordan because I think Jordan is designed to show us what's wrong with our system. And we are losing too many cases. The costs of justice are skyrocketing. No doubt about that. And frankly, I don't know how anybody can have confidence in the system when you go and see this going on a daily basis. I believe complexity makes everyone a loser, and we've created the most complex system possible. We're all trying to fight for what's the best answer and vetting these particular things rather than letting the trial unfold. Everybody's going to be confused because we've made it so freaking complex, and that is a disease that is really endemic to this area of the law. Anything we can do? I think there's a lot we can do. First of all, we need to acknowledge the system is in crisis. This is not a small thing. We need to recognize that if we're going to make changes, we need to engage in real discussion. Sooner or later, we've got to come together and figure out if we can do this any better than we're doing it. Or I don't know, we're in real trouble. There are lots of solutions. The problem is that the solutions are not politically popular with everyone. And once we start to getting them into a discussion about these things, it goes into the too hard basket and we leave things the way they are. I don't think that's a sustainable way of looking at the criminal justice system. I have all sorts of policy proposals that are designed not to give the defense everything they want, but to try to reach a sensible way of looking at sexual assault that will hopefully allow us to prosecute these cases in a more intelligent way. For example, share this talk, let people know. Where would I start? I think we need a new offense. I just think that there has to be a way to separate the least serious sexual assaults. I really do. And I think this would be useful because it wouldn't have the same stigma. And I know a lot of people don't like that. This is why it's a controversial proposition. But I believe we need to incentivize guilty pleas. You take an offense like unlawful touching, which is for I know every sexual assault is serious, but the ones that are treated in sentencing as more minor, and you say, well, look, we're going to make these a lower penalty and we're going to presume against the SORA order unless you're a repeat offender or there's reason to be concerned. And we allow people to plead guilty. I think that's essential. I would get rid of sexual communications in any situation. I would get rid of them altogether, but at least we could start this way. Get rid of communications relating to the sexual activity that forms the subject matter of the charge. I'm going to make a consequential amendment to section 278.92, but this is the starting point. We have to get rid of these as sexual activity. I would amend section 278.1. I would suggest that this definition is no longer applicable to the records in the hands of the defense regime. The problem right now is that this definition applies to all the sections in the code, production and admissibility. I don't want it to apply to admissibility. We need to narrow the definition. How would I do that? Well, first of all, I'd repeal stage 1. I don't see the point of stage 1 except to delay matters. I would get rid of stage 1. And then second of all, I would amend it. And I would say you have two options. Like, either you repeal the complainant's right to counsel altogether, but no one's going to do that, or at least repeal it in certain stages. I would also amend Section 278, the new section defining records, to either exclude all communications between the accused and the complainant, which would essentially reverse part of the JJ decision, or I would just narrow the definition to limit it to enumerated records, which are the most private, or anything that contains information that would be in an enumerated record. There are solutions. The lack of solutions are not the problem. The problem is the lack of agreement on the fact that there is a crisis and the lack of agreement on what we need to do to fix it. I know that people believe the criminal justice system and the law of sexual assault is in crisis for a host of different reasons. Defense lawyers think that what it's doing is convicting the innocent. Complainants and survivors and groups think that we are doing too much to abuse those who come forward. I'm not here to litigate either of those claims, but I'm here to tell you that if we don't see that what we're doing is strangling the criminal justice system with applications and more applications and confusing standards, we are going to continue down a road in which we are going to lead and we are going to be trying to treating symptoms, triages, and delay loss. And I don't know how we can continue this way because it doesn't seem sustainable to me. I hope, as always, that was of interest to you. And if you like what I've said here, or at least find it interesting as a framework to start discussions, I urge you to share this with people who are interested in making our justice system better. I welcome your comments and questions, and I wish all of you a great day.